Many folks in the CMMC space have heard about this mysterious and scary acronym FCA, which of course does not stand for Fund Compliance Adventures as much as we all hope that would be the case, but instead the False Claims Act. Now, while many know this is a mechanism used by the Department of Justice to potentially sue contractors for making false claims on their compliance, among other things, there's a lot of nuance to this topic. So I decided to sit down with someone who knows this way better than me, an actual lawyer. And not just any lawyer, Eric Crusius. Eric is a partner in Hunton Andrew Kurth's DC office, focusing on government contracts and cybersecurity privacy law. I first met Eric after seeing him give an incredible talk on the False Claims Act as it pertains to DFAR 7012 clauses, 1920, and overall CMMC. So in this episode, we better understand what exactly the False Claims Act is, what examples are of cases, who typically comes about, how these come about, and what defense contractors should watch out for in upcoming CMMC requirements to help avoid a False Claims Act of your own. So I hope you enjoyed this conversation as much as I did with Eric Crusius on this episode of Mostly Compliant. Eric Crusius, thank you again for joining me on Mostly Compliant podcast here. Very excited to dive into some topics around the False Claims Act from somebody who knows it way better than I, an actual lawyer and a lawyer who specializes in this. So that would probably be a good place to start. Do you mind just, I did a little bit of an intro, but you give anybody that's listening a little bit of background on yourself, your specialty, how this kind of relates to CMMC compliance and your specialty in that area.
Sure. And so your viewers just know this is not, unfortunately, my regular office. I was working out of my DC office this morning, but had a lunch out here in Virginia and decided to come back home and find a comfortable spot to talk to you. So appreciate the time. And False Claims Act, my goodness, we could talk about it for hours and hours, but won't do that to your viewers and listeners out there. But essentially, high level, it's, did the government get the benefit of its bargain? When the government bought something, did the contractor provide what the government thought it was getting, what the contractor said to the government it was providing to them? And that, this act started during the Civil War, where union companies were providing sawdust, as opposed to things that can go boom. They were mixing sawdust and not getting the benefit of the bargain. Not That's good fun. For the union troops. Yeah. So Congress kind of passed the precursor to what we have now today under the False Claims Act. And that could take the form of, hey, what we bought wasn't what we thought we were going to get. And that can mean you didn't comply with the regulations that you were supposed to comply with because you were supposed to be protecting the information we gave you, kind of thing. And it can't be like you said that you were going to provide 5 yellow computers and they're just a shade off of yellow, right? That's not necessarily material unless like that color was super important to the government for some reason. It has to be something that's material to the government. And then the question is, in our context of our conversation, are these cybersecurity regulations material? And thinking about not just CMMC, but the precursors, the regulations that contractors have to comply with now, DoD has long said that those are material parts of the contract. So their position is, and they haven't lost in court on it yet, is that these cyber regs are material. And if you don't comply with these cyber regs, we reserve the right to accuse you of violating the False Claims Act.
That's a good point there, that they had never lost. I guess I intuitively knew that based on looking at the history of these False Claims Act, but I hadn't really necessarily put that together into one sentence. So that's a really good point. So let's dive into that a little bit. So as it pertains to the cybersecurity requirements, typically looking at like DFAR 7012, 1920, but now again, thinking ahead to CMMC, if you are, falsely attesting to meeting certain requirements, that means the False Claims Act could come down on you. So give a high level overview when people think about this, obviously again, as it pertains to CMMC and these DFARS clauses, this is work with the DoD. Talk about how, who actually comes after you though. It is the actual Department of Justice. And if you don't mind, dive a little bit into okay, but how do they find out? Mm-hmm. How do they find out that you're falsely claiming? What do you typically see?
There's a couple of ways. I mean, the most frequent way that the Department of Justice finds out that something has gone sideways, or at least in their view has gone sideways, is a whistleblower. Somebody in the company comes to the DOJ or files a lawsuit, I should say, in federal court under seal, and accuses the company of not complying with their obligations under, like you said, the 7012 clause, or under the 7019/7020 clauses, which require an accurate supplier performance risk system score. And when those things don't happen, whistleblower, could be anybody, has the right to take this non-public information and go and file a lawsuit off of it and act essentially on the government's behalf and say, hey, government, you're not getting the benefit of your bargain. And then at that point, the Department of Justice has the option of intervening into the case and essentially litigating the rest of the case for the whistleblower, or they have the option of declining intervention. In that case, the whistleblower can, with their lawyer, can determine whether they want to continue on or not. But the most important thing kind of to think about with how these cases get brought about, it's usually, not always, but almost always, a whistleblower that has not been heard. Most whistleblowers are reluctant whistleblowers, and they're out there to protect themselves. They're not out to look to make a few dollars, because whistleblowers do get a cut of any verdicts or settlements usually. So a whistleblower who's out there and filing a case has usually gone to the company first and expressed their concerns and has believed, whether right or wrong, that their concerns have not been addressed. So what I always tell clients to do, that if you get a complaint about anything really, but particularly in this area, really work through it with the employee who's making the allegation, and don't like demote them because of it or give them side eye because of it. Like, say, my gosh, thank you so much for bringing this to our attention. Can you help us work through this issue so we could see what we should be doing differently, if anything, right? And some whistleblowers or would-be whistleblowers don't have any leg to stand on, right? It's not accurate. But in the context of a whistleblower case, it doesn't really matter initially. It may be that they come to the company and say, we think you're not complying with the 7012 clause because you're only complying with 70 of the 110 controls. And it's because they're mistaken about the controls, right? Maybe they have the controls all wrong. But you're going to get halfway around the world before a court figures that out, right? Federal court figures that out. So
yeah,
it's a really good idea to work through those issues, even if you think they're wrong, with the employee before they become a whistleblower, because in the end, almost every False Claims Act case is settled or is dropped. Very, very few of them go to trial. And the cost to the company is the distraction of a case like this. And also, having the Department of Justice breathing down their back is very distracting. And the cost of hiring outside counsel like me is very, it's not insignificant in a case like that, I will say.
That's good to know for you. Yeah.
Yeah. And oftentimes they could have been avoided by kind of engaging with that employee first. Now, there are times when it's just not possible. The employee is taking an unreasonable position, and you've done everything you can, or maybe they don't come to you first, and because their motivation is monetary, maybe. That does happen. But a lot of times these kinds of costly endeavors can be prevented.
Okay.
That's a long answer to your question. And
it's great. So a couple things come to mind. Number one, I do want to officially say on behalf of, I think, every viewer and listener, that your background is not distracting at all. I heard some beautiful ambience, some birds or something, and it's really adding to the quality. So I appreciate it.
Sure.
But I also, so a follow-up. So you mentioned, hey, some of the actual loss that comes with this. You mentioned the distractions and things like that. Talk about the actual financial side of things. Like, what do these settlements typically end up around? Both the actual settlement side, but then you also mentioned the whistleblowers. What are they typically seeing in these cases?
I mean, they typically see about a 25%. It's going to generally be based on, I'll start with your last question first. It's generally going to be based on, has the government intervened? In instances where the government has intervened, the whistleblower's share gets smaller, go down to like 20%. But if the government doesn't intervene, they can get as much as 35% or so, because they've done more of the heavy lifting in the case. So they get a higher percentage. Particularly in the cybersecurity side, we didn't see a ton of False Claims Act cases or settlements until recently. Really seen a ramp up. You think about one that came out recently against Morse Corp, and that was a whistleblower case, and I think it would be helpful to run through the allegations in that case. But DOJ announced the settlement in that case over the summer, I think it was, or late spring, and that was $4.6 million. Right, small business, not a large business. Probably most people who saw that case never heard of the name of the company before. It wasn't like a very famous government contracting company name that everyone has heard of before, where $4.6 million is a rounding error. No, this is a very substantial chunk that would impact the company for years to come. And I think it demonstrates, and this was negotiated and settled by the Trump administration. So I think it demonstrates this administration, they haven't been afraid to use the False Claims Act still. It's just they're using it for different things, right? They're using it for DEI programs, but in the opposite way that maybe the Biden administration used it before. And they're using it on the cybersecurity and kind of these nation state security issues, whether it's supply chain or cybersecurity. They're not going to be afraid to use it for cases like that, or to kind of take out a pretty hefty settlement. And I could run through kind of Morse Corp as an example, because I think it's a really instructive case.
Yeah.
And we don't have a ton of, sure. But if you look at the allegations and what the company was accused of doing, and again, they're all allegations because the case settled, so no court actually said the company, did anything wrong. But one of the very first things that comes to mind is they were accused of not complying with NIST 800-171, which is the standard, the cybersecurity standards that contractors that have control of classified information have to comply with under the 7012 clause, as you mentioned before. And the 7012 clause is interesting because it's been in contracts for a long time. And if you did an honest survey of the defense industrial base, I would say like 75% of them don't have full compliance with the 7012 clause. You look at the number of successful CMMC assessments that have happened so far, it's less than 300, right? And there are over 200,000 companies in the defense industrial base. And DoD expects about 80,000 of them will have controlled and classified information that requires some kind of level 2 certification, whether it's a third party or self-assessment. So that's a very small number. 300 or so is a very small number compared to the eventual number that's going to have to be certified. And I'd say the vast majority of those who have not sought certification yet is because they're not ready to seek certification yet, because I think a lot of them realize it's in their business interest to do that.
Yep.
So you look at what Morse Corp was accused of doing, not compliant with NIST 800-171, and my gosh, DoD can just shake a tree and there'll be thousands of contractors that fall out of that tree that have the same issue. But this one happened to have a whistleblower attached to it. Now, there is a legal argument. It's not a guarantee, but there's a legal argument that says if you do a self-assessment and you realize these 34 controls we don't have in place, so let's do plans of actions and milestones to resolve them at some point in the future. Not a particular date in mind, but you don't want to do it for like 5 years out, like 6 months to a year. There is an argument to be made that you are in compliance. That is an argument I would feel comfortable making to the Department of Justice and the Department of Defense. It has not been tested in court before, so there's no guarantees of success. But I would say if you're a company in that position where you have not gotten those controls in place yet, going through the ones that are not in place and getting POAMs for them, as they're called, the plans of actions and milestones, and having the rigidity of that process in place, if nothing else, will go to show DOJ that you're not being reckless with this control and classified information. So there were 4 things in that Morse Corp case. I think that is the most stunning one in a way, because I think that's the most common thing we see in a DIB. Matt, I'm sure you've seen it before with companies that are coming to you that they're far from compliant with NIST 800-171. It's not an unusual situation. In fact, it's more unusual to have one that's fully compliant at this point. So,
which is interesting, because to your point, in these conversations, initial sales conversations, that they come to us and they say, hey, I know I'm going to need a level 2 certification at some point. Okay, great. Where are you at in your compliance? We're still in the early stages. We're figuring it out. I mean, you're just telling me that you have not been meeting this DFARS clause, right? So it's a very interesting situation to be in.
And I'll just say this just kind of strikes a memory I heard. So I've heard Katie Arrington speak at a number of conferences, and I've had conversations with her. And one point that she's brought up a few times recently is like, we see people complaining on LinkedIn about having to comply with this. And we are taking their names and their information because we're going to look at them. So if you're complaining about complying with this regulatory regime on LinkedIn, that's not a good idea.
But wait, would they qualify as their own whistleblower and then get the money maybe?
That's a good point.
That's funny.
So I could run through these other things on Morse Corp if you want.
Please, yeah.
So the second thing that was, I thought the bottom two things are not as interesting. So the second thing that was the most interesting, I thought, was the allegations they had an inaccurate supplier score under the supplier performance risk system. So I'm not sure how familiar your audience is with this, but a lot of companies now have to go into the supplier performance risk system and state their current state of compliance with NIST 800-171. And it doesn't really matter. It does matter, but in another way, it doesn't really matter what the score is, because you're telling the government, my score is X. And if it's accurate and the government signs a contract with you after that, I would argue that's on the government. Like, hey, our score is -50. And you signed a contract with us 2 months later, and it was in SPURS as -50. I would be hard pressed if I'm the government to make the allegation that it's a False Claims Act, because there's no falsity about it.
Let me ask you a question. Is that just specific to the 1920 clauses then? Or could they still go, well, you're not compliant to 7012, though. You just told us.
I mean, I would want to have poems in place for the rest of them.
Okay.
I mean, that's a great point. I think you do have to be accurate with the government. So you're making an affirmative. I'd rather company be accurate about a -50 than inaccurate and provide a score of like 100 or something like that. And that's what happened with Morse Corp. They did their own self-assessment. Their score was pretty good. It was over 100. And they went back and they had a third party come in. This is all, again, according to DOJ. And when the third party came in and did a review, they found out that the score was actually negative. It was over -100. I think it was a -140 or 147. So not a great score. And excuse me, Morse Corp did not change the score in the supplier performance risk system for a while. In fact, until after a subpoena from the Department of Justice to Morse Corp. So DOJ subpoenaed Morse Corp for these records, and then 3 months later, they changed the score in SPURS. So what I have been telling clients consistently is you're better off giving the government a true state of where you are than giving them an inaccurate state. Like you want to, the government really has folks over a barrel here, right? You can't win for losing. You're either going to give them an accurate score, or you're going to give them an accurate score, which may invite further scrutiny. But at this point, I think I'd rather give them an inaccurate score and potentially invite further scrutiny, but work to solve the problem. So you could show, the government you're working to solve the problem. So that SPURS score issue, again, is one that is not uncommon that you're seeing in the marketplace. I've talked to clients, who have said, oh, I need to update my score. We found out that these other controls we thought we had in place, we don't, whatever reason. I lost my login to SPURS, that kind of thing. It's like, you got to get on that right away. That's one thing they're looking at. And that's one allegation they based the settlement on with Morse Corp. So the other two are not, I wouldn't say are not as interesting. It's just less common scenarios. They also used a cloud service provider that was not FedRAMP moderate. So the information that was being in their environment was not protected adequately.
Yep.
And the last one was they had a system security plan, but it was over a few documents, and DOJ really wanted to see that on one document. Now, that last one, if that was a problem alone, there would be no case, right?
Yeah. It's just, while we're finding these other things we're going to mention is also an issue. Yeah.
Yeah. It's like you go to the dentist and they're doing all this bridge work or whatever. They're doing a bunch of heavy dental work. And it's like, while we're here, do you want me to lighten your teeth a little bit too? Right.
Yeah.
It's like 1% of the issue.
Yeah. That doesn't surprise me, especially about the FedRAMP, non-FedRAMP cloud service provider. I mean, we still see a ton of, ignorance to that in clients that come to us and say, hey, I'm fine. I'm doing all these things. And then you ask them very basic questions around like, hey, anywhere you're sending that in the cloud, is it FedRAMP? I'm sorry, what? So, these sorts of things are not surprising to hear that anybody that's talking to these organizations that are seeking assessment.
Right. And I'll just want to add really quick on FedRAMP. It's FedRAMP moderate or equivalent, right? That's DOD's line. What is equivalency? Well, DOD put out a memo a while back about what equivalency is, and it's you meet all the control sets. You just haven't gotten the certification.
Yeah.
But I would find one that's actually been FedRAMP approved. It's a safer way to go.
Yeah, I have a lot of thoughts on this topic without going down the rabbit hole, because we are a 3PAO, so we do FedRAMP assessments as well as a C3PAO doing CMMC assessments. So this is a nice cross of both of my worlds. So Yeah, so you need to be compliant to the FedRAMP moderate baseline. You need to have a 3PAO come in and assess you, and you need to present a body of evidence showing that you are meeting all of those controls. And counterintuitively, it can be maybe a little bit more difficult than getting FedRAMP authorized because they specifically state in that memo, no POAMs. You can have no POAMs. So you need a perfect score against those 300 plus controls.
I was going to say, there's a lot more controls there too. Yeah.
Yeah, a lot more. Yeah, it's a pretty high bar. So, okay, there's so many different avenues that I want to go down, but I'm trying to be cognizant of time. So one thing that comes to mind is I think there was a recent case where an organization came forward. They said, hey, we have noticed, there's not a whistleblower, but hey, we want to let you know that we now found whatever it was a few years ago that we had an inaccurate score, or, we were not compliant, and they were still hit with a fine. If you have clients today and they find an issue like that, they say, hey, previously, because they're like, hey, we're getting our stuff together now for CMMC. We're going to get CMMC level 2 certified. But as we're getting ready, we kind of looked into things a little bit more. And we found a few years ago, maybe there was some potentially, I don't want to say false claims-y things, but false claims-y things. What would you tell them, or what would you advise them? Maybe not legal advice, but like, what are your thoughts on that?
Yeah, I mean, I'll start by saying it's going to be very circumstantial. It depends on what has or hasn't been done and what the potential outcomes of that are. Do we really feel like this is something that's going to be found out anyway? So let's just get ahead of it while we can. Maybe we know there's a whistleblower coming forward, so we go to the government first. There's mandatory disclosure requirements under the Federal Acquisition Regulations, so you can couch it under that as well. And you send the government a check for what you think their loss was, and you hope that solves the problem. And then it depends on the culture of some companies too. And this is not a criticism of others. It's a business after all. But there are some folks who just feel so guilty when they find something like that, who own a business. They're like, we just got to tell the government. And even if I tell the client, like, from a business standpoint, it's not a great idea, I understand where you're coming from, they still want to do it anyway. And then we get them in the best position to do that, to minimize the potential damage from that. So it's going to come from, it's a great question, Matt, by the way. It's just going to be so circumstantial. My advice could be completely different depending on the circumstances, on what happened, how it happened, who they are. And then sometimes the clients just they're set on a way, no matter what my advice is, right? Even if we've had a long relationship and they trust me intuitively, they have a moral sense that they need to tell the government, or that they don't want to tell the government what's going on one way or the other. And again, it's not a criticism of either side. It's, everyone's a little bit different, wired a little bit differently too. And but it is, you talk about like going off on a tangent, is AI going to take over the legal profession? And there'll be some aspects of the legal profession that are impacted with AI, but talking to your lawyer, whether inside your company or your outside counsel, and talking through these issues, that's like one thing that AI, at least in our lifetimes, won't be able to replace, because it's a big touch and feel thing, because it's just going to be different every time. And it's going to be dependent on also the company's relationship with the client, with the government, and things like that. It just is a lot of different factors that kind of pour into that decision.
Yeah, that's a really good point. I foresee this. I hadn't really thought about it too much until this conversation, that I think as a lot of organizations are now kind of digging up, because in my conversations, they'll, maybe it's a new hire or somebody that they're saying, hey, I'm kind of picking up the pieces as to what we've done in the past. And sometimes the pieces they're picking up kind of spell a story of maybe, they weren't necessarily complying to all these aspects. So that's why I was curious about what they may do. But we understand that it's very circumstantial.
Yeah. And that's actually another great point too, is picking up the pieces. Like, you have to get to a point where you know what happened or what is happening, right? And that sometimes takes some time too, but it's really important to do that as quickly as possible, because the mandatory disclosure requirements under the FAR kind of demand quick action. And if you think that the company has done something wrong, you may want to self-disclose. It's going to be a race to who can go talk to it first, whether a whistleblower or you. So again, you're going to want to move fairly expeditiously, not like tomorrow or even the next week, but you want to keep moving towards a resolution to figure out what happened, and so you can get to a decision point, because you can't decide what to do until you know exactly if there was a shortfall where that was.
Yeah. Yep. Okay, there's a couple other topics that I want to make sure we hit on before we wrap up.
Sure,
they're pretty related, and they are more specific to CMMC, the upcoming DFAR 7021 clause, once 48 CFR gets finalized, and those start the phased rollout into DoD's actual contract requirements. So a couple things on that. Number one, CMMC specifically calls out, and this is how it's been for SPURS scores and things like that, the affirming official, right? The senior company official. Could you talk to us about who that typically is within an organization, what their role is, and what their potential liability is as it pertains to everything we've been talking about.
Well, you're going to hate me again, Matt, because I'm going to come back at you with another. It depends. The affirming official in a smaller company could be the CEO of the company, right? Or it could be the chief information officer if the company even has a CIO. A lot of companies don't even have CISOs; they have CIOs, right? Or chief technology officer, something like that. They have written the rules in a way that gives those companies kind of the flexibility to figure out who that is. But it has to be somebody that has knowledge as to whether these controls are in place.
Okay.
I think that's the last thing you want to do is have an affirming official and the government comes and asks them questions and they're like, I don't know what I signed. Somebody just put this piece of paper in front of me and I signed it. Not a good look ever. So of course that's got to be somebody who understands kind of what the potential outcomes are. I mean, I think a lot of times that action by the affirming official is going to be covered by insurance. So if there's any kind of issues from a monetary standpoint, they're not going to be personally liable for that. But they also have to make sure they do their own due diligence because DOJ in the past has tried to hold individuals personally liable, for making false claims if they do it in a reckless fashion. If I'm an affirming official and I'm in a company and the company is asking me to affirm to something like that, I would want to be sure. I'd want to take a day or two, at least if I haven't been personally involved during the whole process, to run through the process with everybody before I sign such an affirmation. And, for companies out there who I talk to about this, it's like whoever that is, need to kind of work hand in glove with that affirming official. And they're usually the ones supervising the project anyway, so it's not an issue. But to the extent that they're not, maybe they have a more overarching supervision, that's going to be the hook for a False Claims Act case because you're making an affirmative declaration to DOD on something. And you've probably explained this to your audience before, but it's not just like upon a successful CMMC audit or assessment, I should say. It's also after POAMs are closed out, and it's also on those other years because it's a 3-year assessment. Year 2, year 1 anniversary, and the second anniversary, that it's a new affirmation. And so it's got to be somebody who knows the system hasn't changed, the scope hasn't changed, and we're still all good to go. So that's going to, of all the things probably with CMMC, I think that's going to be one of the most interesting things to see how that develops, who those folks are. Because right now there's been 250 to 300 successful assessments. So there's only, what they say is less people who have signed that than have played professional basketball or something like that, right? Because there's so few affirming officials out there right now. So we don't know totally how it's going to net out and what those cases are going to, because there inevitably will be a False Claims Act case involving an affirming official. Just because of the numbers, the sheer numbers, there is going to be one. And what position is DOJ going to take? DOD going to take, and how it's going to net out, we'll see.
So that segues beautifully into what I was wanting to talk about next with that, and that has to do with the ongoing compliance with CMMC and the annual self-attestations. And for those that are maybe less familiar with what we're talking about here, so the senior or the affirming official, previously known as the senior company official, they have to affirm in SPRS your compliance with your CMMC status, right? So They are the ones when we talk about going into SPRS and saying, self-attesting and saying, hey, we're still compliant, or we closed our POAMs, or whatever the trigger is in that mechanism. They are the person that is personally going off and signing off on that, right? So there is an official title that is designated in CMMC as an affirming official who needs to sign off on that. So to Eric's point, you want to make sure that that's somebody that's very knowledgeable on actually what's happening, or has been caught up to speed at least and is not clueless. So to your point, once you get CMMC certified, it is a 3-year certification, but I make sure every client understands that. I feel like a lot of clients are sprinting to the finish line in their eyes being the certification in hand. And I want to make sure that they are aware that there's ongoing compliance requirements beyond that. And one of the main ones is annually, to your point, years 2 and 3, or year 1 anniversary, year 2 anniversary, go in and self-attest that you're still meeting 110 out of 110. So I see kind of a big issue sort of brewing in the distance. That is, everybody's so focused on the certification, they're not even necessarily thinking about years 2 and years 3, which is a little bit understandable. That's a few years away. But I think people need to be wary of the fact that these self-attestations are going to be very important, and they're going to be required. So what is your general take on, I know you kind of touched on the fact that you also foresee maybe some issues with this and some False Claims Act. Could you just expand upon that? So with those year 1 and year 2 anniversary self-attestations, you do feel like that's a lot of potential for False Claims Act if somebody's signing off on that and just saying, hey, we were certified a year ago, so I'm sure we're still good. And I guess my follow-up would be, are there any measures that you would advise clients or organizations seeking assessments on how to go about mitigating that risk that they are falsely self-attesting in those ensuing years?
Right. I mean, we could talk just a few hours on this question alone. It's a great question. I mean, when you kind of talk about the finish line, right? I occasionally run 5K races, right? Try to stay in a little bit of shape, as hard as that is. And when you finish a race, you could just stop, right? You cross the finish line, you could slowly walk to your car, crawl to your car, and that's the end of the race. And that you're done until the next one. This is kind of like you run through the finish line and then you keep walking. And you keep walking and you keep walking, and then you walk until the next start line when you start another race again, which is 3 years later. And I would say that that's what CMMC is like a lot, where, you know, you have this sprint to the finish line, but it's not, like you were saying, Matt, it's not the end of the story. It's like there's still maintenance that has to get done even before then. So, you know, once the affirming official has been identified, they should be in the loop on all systematic changes, boundary changes, things like that happen to the system that has been certified. Like, companies can have multiple systems that have been assessed, right? It's not a company-wide assessment. It's a system assessment. So larger companies in particular are probably going to have a lot of different systems that are assessed. And even medium-sized companies may have multiple ones. And when you look at the affirming official, they should be familiar with that. And they should be familiar with the fact, hey, has the company had any M&A activity, which has caused these systems to combine or change? Have we upgraded our systems in a manner that may change the scope? And that kind of that's a side point, but I think it's really important, is that you're essentially telling the government, this is the system the information is housed on, and it has been assessed. Here's the unique identification number. You could go verify that it's been assessed to whatever level is necessary. And then if the company goes out and changes the system in the interim period, got to tell the contractors and the rules, got to tell the contracting officer within a certain period of time. I think it's 72 hours. And so that means that the affirming official is going to go, or somebody's going to go to the contracting officer and say, we no longer have a system that has been successfully assessed that all your controlled and classified information is on. So it's really important to set up a system and get it successfully assessed before you move stuff before you kind of decommission your old system, essentially, by having it change. So in those in those additional years, it's really just about kind of staying engaged in the process, understanding what the requirements are, understanding the impacts of M&A activity, upgrades, things like that, where the system scope changes.
Yeah.
Then you're starting to really row in the right direction there and continuing that slow pace walk that you need to do in years 2 and years 3. Now, if the system does change materially, where the scope changes, or you're like combining two systems together, that's a new assessment, and that's another sprint, right? The race came up sooner than you thought it would.
Yep.
But that's the safe way to do it.
I was going to say, that wasn't even to speak to significant changes, but then to your point there at the end, if it's deemed significant, you're looking at a full reassessment and a new certification.
Right.
Eric, this has been a great conversation. I don't want to have to stop, but we're going to have to stop. Maybe we'll have to do a part 2 sometime. To your point, I'm sure we could dive into hours worth for each of these different sub bullets. I want to throw it back over to you, though. Anything that you want to close with? Any words of advice? Anything that you want to circle back to and kind of reiterate, or anything that you want to anything upcoming that you want to talk about? Any of that sort of stuff.
I mean, I always tell people this is such a fast developing area. What you're required to do as a company is in your contract. You always have to look to the contract. CMMC is something that's coming, but it's merely a verification of what a company already has to do for levels 1 and 2 anyway. There's a rare instance of level 3 where it could be something new. So I would say, if you're confused about what you should do next, look to your contracts that you have, what cybersecurity and other clauses, but particularly for our conversation, cybersecurity clauses are in there, what compliance requirements are in there because of those clauses, and just work through those, right? I say this, and it's in my self-interest to say it, hire a lawyer who knows this stuff, there are other lawyers besides me out there too who know this stuff. Find one who knows this stuff and work with them.
You know any? Yeah.
Obviously, I'd love for everybody in the world to call me, but there are other capable lawyers too who can help you work through those issues. So whether it's that person or me, talk to them and help them, work with them to work through these issues, because in the end, DoD is taking this very seriously, and it's clear DOJ is too. And the CMMC program, after a few false starts, it's really happening, right? Secretary of Defense mentioned it in a memo recently.
Yep.
By name, the Cybersecurity Maturity Model Certification Program. That, to me, screams like we are using this program to ensure enforcement.
Yep.
Look to the contract.
Look to the contracts. I would agree. I mean, even in initial conversations, when people are talking about whether they have CUI or scoping, or is this something I've had to, be complied with in the past? Like, I'm typically having that conversation as well. I was like, well, was DFAR 7012 in your prior contract clauses and these sorts of things? So I think that's a fantastic piece of advice, fantastic way to end the conversation. So Eric, thank you again for joining us on the episode, and everybody for tuning in and listening. Thank you again, and tune in next time to Mostly Compliant. We'll see you guys later.
Thank you. Appreciate it.